Welcome back to this fourth and final part of the session on duty of care. Our focus in this session is on pure economic loss. Now, the starting point is to consider what is economic loss. Economic loss will usually be either financial loss, consequential on economic loss arising from physical injury or property damage. So, for example, something like loss of earnings following an accident, or pure economic loss. And pure economic loss, of course, arises in other circumstances. Now, the case law has been that up until the 1970s, there could be absolutely no liability in respect of pure economic loss. And the idea, of course, is that there would be too much of a floodgates argument. And if you remember from the first segment when we looked at duty of care, and you were told about the U.S. Judge Benjamin Cordoza's statement that this would undoubtedly cause liability in an indeterminate amount for an indeterminate time to an indeterminate class. Well, if you imagine for a moment that pure economic loss, as we will examine further, would allow you to be open as a defendant, to be open to certain types of liability that you certainly couldn't even have thought about. Now, the examples of pure economic loss, of course, would be things like the loss of income in situations where you have a breadwinner who has died. But then what we have is his family being not going without, meaning that although the physical injury was to the breadwinner, the loss is to the family. So any loss the family would have would certainly amount to pure economic loss. Another type of pure economic loss, of course, is where you look at the market value of a property and you have your property where over time it has, for some reason or another, preferably in our circumstances here, because of the defendant's negligence, it loses its value. Now, again, I will take you back to the first lecture where we looked at Anne's and Merton London Borough Council, because in that we see that the loss in respect of what Mr. Anne suffered was that the value of his property had reduced. There's also, of course, the loss of production because of somebody else's fault. And this we will see clearly, as we will discuss later, comes out in the case of Spartan Steel and Alloys. Now, the court has been consistent. It has said repeatedly and categorically that there is no recovery where the loss is purely economic loss. Now, you must draw a distinction between pure economic loss and consequential economic loss. A case which actually shows the both types of losses very well is the case of Spartan Steel and Alloys in 1972. Now, in Spartan Steel and Alloys, the plaintiff were factory owners and the defendant were persons working outside doing some type of excavating work. Now, the electricity to the plaintiff's factory ran along the path where this excavation was being carried out. The defendant negligently cut the electricity cable running to the factory. Now, what then occurred, of course, was that the factory lost power and had no electricity for about 15 hours. Now, there was some damage suffered, and I want us to examine the type of damage that occurred very carefully, because there was the issue of the type of work that the factory did. And without getting too complicated, it involved where they had to melt some type of metal. And basically, they had a furnace that they used to do this. Now, there was a melt in the furnace at the time. There was another melt on the floor waiting to be put in the furnace. And then, of course, there was the 15 hours that the factory had lost. So, there was the physical damage to the factory's furnaces and the metal, the lost profit on the damaged metal, and of course the lost profit on the metal that was not yet put in. So question, what are they going to be able to claim for? As I said, you cannot claim for pure economic loss, but you can claim for consequential economic loss. So let's examine what would fall in either category. Well, in respect of the melt that was in the oven or in the furnace, the fact that the electricity was cut and it meant it damaged the furnace itself, well, the damage of the furnace itself would be physical injury. So you can claim for that because that is direct. The melt that was in the oven, you could also recover because that is what amounts to consequential economic loss. But here is the thing. The melt that was waiting to go into the oven, what about the profit on that melt? Well, the court said that that amounted to pure economic loss because nothing was wrong with the melt waiting to go into the furnace. It was just that they had lost the profit on it because it wasn't dealt with that day. So, all in all, when you look at the physical damage and the lost profit on the melt that was directly consequential, then those could be recovered. So, again, by way of recap, your two types of economic loss are economic loss consequential on physical damage and pure economic loss. And of course, you can only recover the former. Now, there have been a series of cases relating to defective property where we see the courts going down a path of allowing recovery where there has been a defective property scenario. Now, what tends to happen in these cases is that the claimant owns property, but then he finds out after that it has a defect. What will then happen is that he spends money repairing the property and that he has acquired, and then he has to expend this money. And what we have seen is that in a slew of cases, the courts have had to consider whether or not recovery is possible. Well, in the case of Anson Merton, which again, I refer you to the first segment of this video, in Anson Merton, we see that that had to do with a defective building case, and we see categorically that the court has said in Murphy and Brentwood that in Ans, that cannot be the case anymore because that amounted to pure economic loss. Here's a hint. The fact that Mr. Ans could actually calculate a figure in respect of his loss, so he could see that what he has lost is the value of what it is now versus what it would be without the defect, suggests that that is pure economic loss. Now, the House of Lords has tried to establish some sort of general duty of care based on the closeness in respect of parties and how those parties have dealt with each other in a relationship. Case that I'm thinking about here is the case of Junior Books and Vecchi. Now, in Junior Books and Vecchi in 1982, the case is a unique one, and even to date, you will find that no other case has ever followed Junior Books, but it still stands as a case in its own right. It's not been overruled, but in Junior Books, we see where the company, the claimant, had hired Vecchi to put in a floor because he was building this study, this library, and the floor cracked. The problem was the people who did the floor were subcontractors with whom Junior Books did not have a contract. So of course they couldn't bring a contract claim because privity of contract would have vitiated against that. So they brought it in tort. The problem, of course, is that that type of liability then causes some problems because we see the development of a type of duty which was previously unknown. Now, by and large, we have seen that there has been a retreat from the junior books type cases. And of course, the two main cases for that are Muirhead and Industrial Tank Specialties and Simon General and Pilkington Glass. And I would, of course, urge you to look at those cases because it shows you that although junior books has been criticized, it has not been overruled. Now, though, we get to the meat of what you have to consider when you look at pure economic loss. Because by and large, if you get a question that says there is no liability for causing pure economic loss, that is not strictly true. Because in the context of negligent misstatement, you can recover for pure economic loss. Let's consider that for a minute. What is the starting point? Well, historically, we go back to a case called Darien Peak in the late 19th century. And in Darien Peak, the court said that if you make a statement which causes someone loss, liability will not attach unless it is fraudulent. Now, to pause here for a minute and let you understand this, the fact is that if loss is suffered based on a statement, then clearly it can only be pure economic loss because nobody would have been caused physical injury and no property damage would have occurred. It's a situation, for example, where somebody says to me, invest in company A, and I invest in company A. I have not been harmed physically. I haven't lost any property, but I've certainly lost money, which of course is pure economic loss. So in Darien Peak, the court said, if you make a statement, liability will only attach if the statement is fraudulent. Now, in a case in 1952, Lord Denning in Candler and Crane Christmas said he was concerned that liability did not attach to a negligent statement because, in his words, he said statements tend to have a far wider reach than actions, which makes sense. But that, of course, was a dissenting judgment by Lord Denning in Candler and Crane Christmas. When we get to Hedley Byrne and Heller, though, which was a case approximately 12 years later, because Candler and Crane Christmas was about 1952, Hedley Byrne and Heller in 1964, basically the court seized the metal here, and they basically said that as far as they were concerned, liability could attach in respect of negligent misstatement. So they more or less approved Lord Denning's dissenting judgment in Candler and Crane Christmas. It is an unusual type case to the extent that in the case itself, they did not find that liability attached to the defendant in the case itself. So it is more or less obiter, but it does stand for the proposition. And what happened in Hedley Byrne and Heller was that the courts considered that the special relationship between the parties was a factor going to determining whether or not liability would lie. Now, there's one thing that is extremely important for you to understand, and it is that the usual principles of Donahue and Stevenson will not apply in the context of negligent misstatement. So if you go back to Donahue and Stevenson, for there to be a duty of care, if you remember, there has to be foreseeability, proximity, and it is just, fair, and reasonable for liability to attach. The thing is that with Caparo, which refined Donahue for actions, Caparo also refined Hedley Byrne. So sometimes law students get a little bit confused when they look at duty of care in terms of negligent misstatement because they tend to want to go back to using proximity, reasonable foresight, and so on. But that's the wrong test. You still will cite Caparo, but the test is different in respect of negligent misstatement. what has to happen is that there must be a special relationship between the parties. Now, in Headley Byrne, just by way of the brief facts, what occurred in the case was that the bank was asked by Headley Byrne whether or not Easy Power, who they were considering giving credit to, whether or not Easy Power were good for the money, as it were. And the bank more or less wrote back and said, yes, for whatever you're considering to give to them, they are creditworthy. Unfortunately, they went bust shortly after. And the question was whether or not the bank had to pay them back the money, which was somewhere in the region of about £17,000, which would have been an awful lot of money back in 1964. But the thing was, and the reason the court did not find against the bank in that case was because there was a disclaimer which said that we would not be held liable in the event that this statement wasn't correct. So even though the case stands for the proposition, in the case itself, the bank was not held liable. And the court said for liability to attach in Headley Byrne, there had to be a special relationship. Now in Caparo and Dickman, Lord Oliver has set out the 4 requirements which are necessary to show that there is a special relationship. And this is where it has refined Headley Byrne. And there are these. The first is that the advisor must know, either actually or by inference, that the advice was needed for a purpose. The advisor must also know that the advice would be communicated to the advisee. And it must also have been known that the advice would be acted upon without independent inquiry, and further, it was acted upon by the advisee to his detriment. Now, the House of Lords looked at Headley Byrne in a couple of later cases, but I want you to consider for a minute those 4 points. If you were to look at this in an exam situation, the point to make is that when you are asked, for example, where they say to you somebody has made a statement to somebody else, for example, given investment advice, and the person loses money, the issue, of course, is that that person who has lost the money, it is the third point which generally allows liability not to attach. Did the person giving the advice know that the advisee would not have sought independent advice? Now, the 2 later cases that were considered were Smith and Eric Bush and Caparo and Dickman. Of course, Caparo we've discussed at some length earlier, but in Smith and Eric Bush, what we had was a strange situation where the bank had asked Eric Bush, a surveyor, to survey the property that they were intending to lend Miss Smith monies to purchase. So they were intending to have Miss Smith have a mortgage. Now, Miss Smith did not pay Eric Bush. The bank did. So the question is, did Headley Byrne liability attach in this case, given that the statement, as it were, meaning the survey report, was made to the bank and not to Miss Smith? Well, the court said, yes, it did, because she was of the persons that they should have thought about. Now, with Caparo and Dickman, of course, this was a situation where certain accounts were overstated, and the issue here was whether or not the bidder, who was the takeover bidder, relied on the statements that were made by the auditors in purchasing shares and in also taking over the business, based on the fact that they were told in the report that the company's finances were sound. The question was, could they bring a successful action against the auditors who provided the auditor's report? Well, at first instance, the court said, no, there's no liability attaching. The Court of Appeal, of course, had different ideas, and they said that liability could attach in certain circumstances, but not in others. But in the House of Lords said there was absolutely no liability to anybody whatsoever. The court said that the range of persons would be too far and too wide. In fact, the case of Morgan Crucible and Hill Samuel are on facts very similar to Headley Byrne, and I would ask you to look at Morgan Crucible and to, on Caparo, to look at Morgan Crucible and to look at Caparo. The facts are similar, but the decisions are different. Now, advice on social occasions, be very careful of those. You are or will be lawyers, and so if somebody asks you for advice, be very aware that it may very well be that you're liable even if they don't pay you any money. You are lawyers, and the only thing you sell is your time and your knowledge, because in Chaudhry and Prabhakar, that's pretty much what happened, is that here we see Mr. Prabhakar being asked by his friend about the state of a car she was buying. He obliged, and the next thing is he finds himself liable when the vehicle was worthless. The point of assumption of responsibility is another aspect in considering whether or not a duty of care can arise. And this basically is where there is a contractual situation coupled with a tortious potential liability. So a duty of care in tort can coexist with a duty of care in contract. And this is what is called concurrent liability, because a duty of care in contract and tort, notwithstanding that the original was in contract, is completely acceptable. Meaning that even if I'm in a contractual relationship with you, if the circumstances are such that it could give rise to a tort, then there may be a duty of care, because contract and tort together are called the common law of obligations. Now, in respect of the liability in the case of Henderson and Merritt, the court said that Lloyd's names were liable in respect of having their monies returned to them, meaning that the courts considered that the names at Lloyd's were owed a duty. That is, when they put their monies in order to ensure that they were being dealt with properly by the underwriters, albeit that there was a contractual obligation, it was sufficient for tortious liability to arise. Now, in the case of White and Jones, that is also another good case to look at. It was one where a solicitor who had instructions from a testator, but it was the beneficiaries who brought the action. Now, the high watermark, of course, is the case of Williams and Natural Life Food. Now, this is an interesting case because this is the case where the court said that where Headley Byrne liability is being extended, it will not go that far to include liability where, for example, you're looking at a situation where you have a franchise. Headley Byrne liability will be extended in certain situations. So, for example, where A makes a statement to B causing B loss, that's your typical Headley Byrne principle. But what if A makes a statement to B causing C loss? Well, cases like Spring and Guardian Insurance says yes, liability will attach. But certainly when we look at Williams and Natural Life, and again, I would urge you to have a look at that case, because at that point, the courts have said we will not take it any further than that. Now, that ends this first session on duty of care in negligence, and I hope you'll join me for the second session, which looks at a breach of duty of care.